Hello everyone. In today's video, I'll be discussing Article 23 and 24. So let's get started without any delay. Article 23 and 24 provides fundamental rights against exploitation. The exploitation of lower caste by the upper caste, practices like Sati Pratha, Devdasi system, forced prostitution, human trafficking and employment of children in hazardous industries are some of the very common incidences of exploitation in India. Though Article 23 and 24, the Constitution of India expressly mentions its commitment to save human beings from the scourge of exploitation. Now let's understand the meaning of exploitation. The word exploitation is borrowed from French. Exploitation means depriving a person of his due through force or fraud. When a person is denied his share, reward or remuneration for his contribution of labor and service for producing the wealth, then it is known as exploitation. Now let's understand Article 23. So Article 23 provides the prohibition of trafficking of human beings and forced labor. Article 23, Clause 1 prohibits three aspects of exploitation. Number 1, trafficking. Number 2, begari system. Number 3, forced labor. And it mandates that any contravention of such prohibition shall be an offence. The Parliament has power under Article 35 to make a law prescribing punishment for all those acts which are prohibited under Part 3 of the Constitution. In pursuance of such power, Parliament has enacted several laws prohibiting forced labor, begari system, trafficking, etc. Laws passed by the Parliament in pursuance of Article 23 are as follows. I'll tell you the names of two of these acts. Number 1 is Suppression of Immoral Traffic in Women and Girls Act. This act is of 1953, and the second act is Bonded Labor System Abolition Act of 1976. So now let's see what is human trafficking. So it means the sale and purchase of human beings mostly for sexual slavery, forced prostitution or forced labor. Slavery is not expressly mentioned in Article 23, but it is included within the meaning of trafficking in human beings. And when it comes to begari system, it means forcing a person to work for no remuneration. A person is compelled to work against his will. And at last, we have other forms of forced labor. If the less than minimum wage is paid, it is known as forced labor. Calcutta High Court, in one of its cases, Dulal Samanta versus District Magistrate, interpreted the expression other similar forms of forced labor provided under Article 23. The court held that the expression is to be interpreted as judem generis and it has to be something like either traffic in human beings or begar. Now there is one exception, which is ban against traffic in human beings is absolute, but ban against forced labor is subject to one of the exceptions as mentioned under Article 23 Clause 2. Now let's see Clause 2 to understand it in a better way. So it states that the state can impose compulsory services for the public purpose like national defense, removal of illiteracy or the smooth running of public utility services like water, electricity, postage, rail, air services, etc. In making any such provision compulsory for public purposes, the state cannot discriminate on the grounds of religion, race, caste or class or any of them. Now you'll see sex is not mentioned as a prohibition ground for the discrimination, which indicates that women could be exempted from compulsory public services. However, no such law at the central level is made in India so far in its history. It is an interesting fact that for a very short period there was a law in Nagaland that stated that in case of impeding blood able bodies, persons can be called to join the army. So now let's go through some important judgments on the rights against exploitation, that is Article 23. Number 1 is People's Union of Democratic Rights versus Union of India. This case is of 1983. You can write it down. So in this case, the Supreme Court interpreted the scope of Article 23. The petitioner scrutinized the working conditions of various people employed in various projects. It was discovered that the laborers were subject to great exploitation. They were not given minimum wages, subjected to an inhuman working environment, and a PIL was filed. So, Justice P. N. Bhagwati observed in this case that the scope of Article 23 is very vast and unlimited, and it is not merely begar which is prohibited, but this article strikes at forced labor in which form it may exist, in whatever form. Every form of forced labor is prohibited. No person shall be forced to provide labor or services against his will, even if it is mentioned under the contract of service. The word force has a very wide meaning under Article 23. It not only includes physical or legal force but also recognizes economic circumstances which compel a person to work against his will on less than minimum wage. Number two, the second case is of Sanjeet Roy versus State of Rajasthan. This case is of 1983. So in this case, the state had employed people for the construction of roads and their work was allowed under the Feminine Relief Act. These workers were paid way less than the minimum wages, and it was contended that this payment of wages lower than the minimum wage was violative of Article 23. The court in this case held that the state is not allowed to take undue advantage of the helplessness of people with an excuse of helping them to meet the situation of famine or drought. The court observed that they must be paid fairly for the work into which they are put, and they put their efforts and sweat, and which provides benefit to the state. Third case is the very famous case of Bandhua Mukti Morcha versus Union of India. This case is also of 1984. In this case, Bandhua, we all know this case. Bandhua Mukti Morcha is an organization that works against the prevalent system of bonded laborers in India. So this case is special in the sense that the court for the first time accepted and treated a letter written to Honorable Justice Bhagwati as a petition for PIL. The letter described the ordeal of the large number of workers in the Faridabad district of UP who were working in inhuman and intolerable conditions. The court laid down guidelines for the discrimination of bonded laborers and pointed out that it was the duty of the state government to identify, release and rehabilitate the bonded laborers. So that's it for Article 23. Now let's quickly move towards Article 24, which states about prohibition of employment of children in factories, etc. So Article 24 must be read with Article 39 Clause E and Article 39 Clause F of DPSPs, which provides for the protection of health and strength of children and that the tender age of children should not be abused. Article 24 prohibits employment of children below 14 years of age in any factory, mines or any other hazardous employment. The Supreme Court, in very famous case of People's Union of Democratic Rights versus Union of India, this case is of 1982, held that the building construction work was such hazardous employment where children below the age of 14 years should not be employed. The court also pointed out the horizontal nature of Article 24 and the prohibition of Article 24 could be enforced against everyone, whether state or a private individual. In a very famous case, next is a very famous case of NCMehta versus State of Tamil Nadu. In this case, NCMehta brought before the court a plight of children engaged in Sivakaski cracker factories. In this case, the Supreme Court directed the setting up of Child Labour Rehabilitation Welfare Fund and asked the employer to pay Rs 20,000 as the compensation to each child. India is also a signatory to the Convention on the Rights of Child. It is of 1989. Article 32 of the Convention requires that each state party to the Convention shall protect the children from economic exploitation and any hazardous work. India ratified this convention in 1999. In pursuance of the obligation under Article 24, the International Instruments Parliament has enacted various laws against child labour. Number 1 is Factories Act of 1948, Mines Act of 1952, the Beedi and Cigar Workers Condition of Employment Act 1966, and the Apprentices Act 1961, the Employment of Children Act 1938, and many more. So the Child Labour Prohibition and Regulation Amendment Act, which is of 2016, amended the Child Labour Prohibition and Regulation Act of 1986 And this Amendment Act prohibited the employment of children below 14 years of age in all occupation and industries except those run by the child's own family. Before the amendment, employment of children below 14 years or in domestic work was completely legal. So, a complete prohibition has been imposed on the employment of child labor, that is, a person below the age of 14 years, in any establishment, whether it is hazardous or not. A child is permitted to work only to help the family in family enterprises after schooling, after the school hours or during vacations. So India finally ratified this convention number 182 of the International Labour Organization, which deals with the prohibition and elimination of the worst forms of child labour and provides that no child shall be employed in the hazardous occupation. Interestingly, India is one of the last countries to ratify the convention. Nevertheless, the act introduced a new category called the adolescents, which covered persons between 14 to 18 years of age, and the amendment permits the employment of adolescent labor except in hazardous processes or occupation. The number of hazardous occupations and processes have been reduced from 83 to only 3 mining explosives occupations mentioned in the Factories Act of 1948. It leaves child open to employment in all other kinds of hazardous industries, including construction, brick mills, glass factories, and garbage picking. It provides for the setting up of child and adolescent labor rehabilitation fund, in which all amount of penalty have to be realized. This provision has been drawn from NCMehta's judgment. So the amendment has been this amendment has been widely criticized for being toothless, and instead of eradicating child labor by its very root, it rather makes way for the child labor to thrive. So now I'll conclude my discussion with the following points. So the existence of the practices like exploitation and child labor is a blot on the civilized society. The truth remains that despite numerous laws made in pursuance of Article 23 and 24, we are still far away from achieving a status of a zero exploitation. Instead, India is a home to 10 million child laborers and more than 42.7 million children out of the school. The exploitation of the weak by the stronger continues unabated. Forced labor, bonded labor, trafficking still continues to exist, and the thirst need to be on education awareness, concentrate efforts on part of the concerned authorities, generation of funds, creating employment opportunities, and curbing the evil. So that's it for today. Hope you find this session helpful. Thank you.